Please, my lord.
Give us only 1 second to. The electronic housekeeping work has been carried.
May please, my lords. My lords, my written submissions are volume 2E.
Volume
2E. My lords, first I'll take the issue of intoxicating liquor under entry 8, list 2, my lords. That is at page 21, para 34. My lords, Constituent Assembly debates were referred to, but the page 21, PDF page 21, para 34. My lord, this CAD debate was not pointed out, my lords. This is in relation to Article 47 of the Directive Principles, my lords. And in intoxicating liquor and intoxicating drinks have been interchangeably used, my lords. If my lords have it at the bottom where I've quoted, this is Honorable Shri B.G. Kher. He says, I do not wish to speak at length on prohibition because after very deliberate consideration and prolonged discussion, most of the provincial governments and most of those who are interested in the progress of this country have accepted the necessity of protecting our people from going to their ruin by the use of intoxicating drugs and liquor. My lords may note this word. The use of intoxicating drugs and liquors do not affect the moral sense of a person who uses them. Therefore, it is in the sense of beverage, my lords. Then, my lords may have on the next page, para 22, it continues, my lords. The very object of introducing the amendment, which I am very happy to find, has been accepted by the Honorable Dr. Ambedkar, who is in charge of the bill, is to prevent the furtherance of vice. It is argued that the use of intoxicating liquors and induced drugs. So, intoxicating liquor and intoxicating drink have been interchangeably used, my lords. This has also been noted by Mr. Sirvai in his book.
So, liquor, intoxicating liquor and liquor has been used.
Yes, an intoxicating drink, when ultimately Article 47 came, it used the word intoxicating drinks. So, intoxicating liquor has been used in that sense only, my lords. And Mr. Sirvai's quote has been already pointed out to my lords. In that, so I am not repeating that. That is in paragraph 38 of my written submission, my lords. My lords, directive principles, all the fields, my lords, have paragraph 35 for a moment, my lords. The fields enumerated in the directive principles find place by and large in one or the other lists of the 7 schedule, my lords. Article 47, I have given Appendix 2, my lords, which this is at page 41 of the written submissions, my lords. This gives the comparison of which are articles and which is the legislative entry. But para 35, read with Appendix 2. That is at page 41, PDF page 41. My lords, the only thing what I would like to point out, the most important entry has been missed out in this appendix, my lords, which my lords may add at page 44, serial number 11. Entry 8 of list 2 has to be added in that, my lords. This has been missed out in the comparative chart appendix 2, my lords. Now coming back to
Yes.
my lords, if alcohol, entry 8 talks about intoxicating liquor, my lords. If alcoholic liquor has to be added in that, it has to take color from the other entries in the same list, my lords. And I am saying so because when the Law Commission report recommended that all alcohol be included in the state list, that was not accepted by the Parliament, and they restricted only potable alcohol, and non-potable alcohol was under the IDR, my lords. Therefore, they were very much conscious of the fact that the state has only the power to the extent of potable alcohol and no further.
Yes. What is the next point?
My lords, next point is power to legislate on 245 to 46.
We take it as a second point.
Second point is the scope of 245, 246 and 254. This is at page 6 of my written submissions, my lords. Paragraph 4.
Tell us that again, please.
Paragraph 4, I have summarized 240. My lords may have 245 and 246 for a moment. Then I come to that, my lords.
What para?
Page? My lords, Constitution, my lords may have it.
Okay.
Article 245 to 46.
Why don't you tell us what's the point that you're making?
246, 1 and 2 starts with notwithstanding, that is non-obstante clause, and clause 3 of Article 246, subject to, my lords.
That's
And this is the enabling provision to make laws. My lords, when we go to Article 254 for the repugnancy, it talks about laws made by the Parliament. So once the law has been made by the Parliament, then the test of repugnancy will take place vis-a-vis the state law, my lords. And if a law, Parliament has made the law, then to that extent, the state will be denuded of its power.
45, you are right, because we have discussed it. Yeah,
Right, my lord.
What is the next point?
My lords, now here, once the field is occupied, my lords may have 162, Article 162 for a moment.
What's the point you're making?
My
That the
lords,
executive power of the state is coextensive with the legislature.
No, my lords, proviso to 162 is very important.
Yes.
May I read, my lords? Provided that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. In my humble submission, my lords, under the IDR Act, specific executive powers have been conferred on the central government, my lords. Like in 18G, it can notify, then there are other provisions. So once that power is there, the state is denuded of all its power, including legislative and executive power, to make laws in respect of IDR Act, my lords. Issues in this regard, my lords, there is one constitution-based decision, 2016, volume 7, SCC 1.
Where is it? Where do we find it in the compilation?
It is not in the, because it was
What does it
I
say?
have given 2016, 7 SCC, page 1. Union of India versus, my lords, para 140. My lords may have it. I won't read the entire discussion, my lords. Para 140.
What is the point that you are stating?
My lords, the executive power under 162. Because my submission is the act has been enacted under the legislative power, supplementary volume.
And para?
Para 20 at 462. Voting law Denning, my lords. And then this was later relied on 2014 4 SCC 720 para 70.
2014 4 SCC
720 para 70.
The earlier judgment, is it in the compilation?
No, it's not. It's
Second one also not. All right, thank you, Mr. Agrawal.
My lords, one more thing. My lords, Mr. Balbir Singh, while appearing for Maharashtra, said we are following BIS standards of denaturance, my lords. My client used BIS standard and is being prosecuted because they say it is our standards which have to be taken and not BIS standard. Thank you.
You are satisfied now that you've given me a full hearing?
My lord,
Thank you.
the only thing is, my
I
lord,
must compliment you. You are also very precise and absolutely on the point. So we
my
appreciate.
lord, I may be permitted to file a 2-page.
No, I don't file 2 pages now. You filed so many pages.
Deeply obliged.
Yes, Mr. Mandal.
Because I'm only going to take 5 to 7 minutes. I filed a very short note, which is at volume 2H. Because my other submission can be ignored because it will be repetitive to what others have filed. So I filed now 2H, Milos, which is a very short note. Volume 2H.
Volume
2H.
Alcohol. One, I had already told my Lord the Chief Justice about Mr. Nariman, Lord, but the most oft-quoted couplet in Urdu about alcohol is that, Zahid means, the cleric means, and it said, Zahid sharab peene de masjid mein baith kar, ya wo jagah bata de jahan par khuda na ho.
Beautiful.
Look, my first argument is that the decision of Bombay High Court in Balsara is the right decision and gives the correct interpretation to the term intoxicating liquor. And that's para A of my note. Bombay High Court reasons this in about 4 or 5 or 6 lines, and I've quoted that exact paragraph. If my lords looks, my lords, it says in the first instance, liquor ordinarily means a strong drink as opposed to a soft drink, but it must in any event be a beverage which is ordinarily drunk. Now, the other side wants to argue that the term liquor comes from liqueur, and therefore please extend it to also include liquids. But if one looks at the Constitution itself, the Constitution in entry 53 list 1 uses the word liquids. So liquor and liquids cannot be interchanged.
Where does the Constitution use? Yes, of course.
At entry 53 list 1, liquids is a term used in a non-consumption manner. So therefore, to extend liquor to mean liquids, the answer is in the Constitution itself, because Constitution uses the word liquids when it wants to use the word liquids. That's at entry 53 list 1. So as far as liquor's definition given in Balsara's High Court judgment, meaning a strong drink, that's the correct one. Then second reason why Balsara High Court states that it's for human consumption is because then it goes on to define what is the meaning of the term intoxication. And it says, very interestingly, in the second place, the use of the word intoxicating in item number 31 in contradistinction to the use of the word alcoholic in item number 40A as qualifying the word liquor is very significant. We may also point out that in the white paper, item 26, which corresponded to entry 31, used the word alcoholic liquors, which have in Government of India Act been changed into intoxicating liquors. Therefore, it is apparent that from the class of alcoholic drinks, non-intoxicating drinks are excluded by this entry. Thirdly, medicinal and toilet preparations containing alcohol which are found in entry 46 are neither liquor nor intoxicating, and therefore they are obviously excluded from the scope of item number 31. So, my lords, there it reaches the conclusion why intoxicating should be something for human consumption. My lords, then if one steps back and looks at Article 47, why is entry 8 worded in the way it is worded. If one looks at entry 25, one will see that when they wanted to do gas and gas works, they said gas and gas works full stop. But when they drafted entry 8, they gave it with full splendor. That is to say production, manufacture, supply. That is because if one steps back and looks what the state is vested with, the state is vested with every power to achieve and fulfill what Article 47 Directive Principle mandates it to do. Therefore, entry 8 had all these words to ensure that if state wants to fulfill its objective under 47, it can do that in enough powers there. That's why entry 6 also public sanitation is with the state. And more importantly, entry 51 list 2 gives state full power to levy excise duty on potable alcohol. So this all flows from 47. Because to achieve the purpose in 47, entry 6, public health and sanitation, entry 51, tax on excise duty, and lastly but not least, entry 8, list 2, which is, that is to say, production, manufacture, supply, everything is vested as far as potable alcohol is concerned with the state, so that it can fulfill its objectives under Article 47. So my humble submission is that the definition of intoxicating liquors, one can see what it means by looking at the Constitution itself. Then, my lords, I cite after that, there was an argument made that if you look at the Indian Government Act of 1935, and you look at the local acts in and around that period, then intoxicating liquor, especially liquor, could mean liquids also. But my lords, the only point I'm making here is that even under the Indian Government Act, there was a Power Alcohol Act of 1948, which Synthetics 2 has looked at, and therefore so from those days itself, industrial alcohol is within the centre's control. Now, Millets, para 2 of my note, Millets, I have actually set out where all the term intoxicating is used in the Constitution. It's very interesting. Article 47, then there is Article 36629AF, and then there is Schedule 7, Entry 8. All these three places where the term intoxicating is used is in connotation for human consumption. There is one more place which my note left out, Millets, which is Schedule 6 of Entry 3B. Which deals with special laws for Bodo land. There also it's for human consumption.
Just 1 second.
But para 2 of my note.
In Article 47, Article 366,
29 AF.
and entry 8.
Yes.
And which was the final
and
one?
And then Millets, one final which is left out is Schedule 6, Entry 3B. The Constitution. All Millets are in the context of something which can be consumed. Intoxicating has never been used in the Constitution in the context cannot be consumed or not fit for human consumption. So, Millets, that's as far as intoxicating liquor is concerned. Now, Millets, the second point I want to make is, Millets, I feel, Millets, the case of Tilak Ram was dealt with. What was not dealt with in reply, I suppose, was the Calcutta Gas Company case, which follows Tilak Ram. Now, Calcutta Gas Company case, Millets, I don't need to go as far as saying, please overrule these judgments. Tikaram, I'm sorry. Calcutta Gas Company case, I don't need to go as far to say, please overrule Calcutta Gas Company to make me reach where I want to reach. According to me, if one looks at Calcutta Gas Company case and looks at the reasoning of Calcutta Gas Company case, it supports me, because the way they dealt with the analysis, if that same analysis is applied, then entry 8 would exclude industrial alcohol. And I've cited a very interesting paragraph from Calcutta Gas, which was the key paragraph, where Calcutta Gas was trying to look at entry 25, which said gas and gas.
That para 9 that you quoted page?
Yes, I've quoted, yes. From para 6 I've quoted it, and I've quoted para 9 of the judgment. There's a second page of the quotation of the judgment where I've underlined in bold. There, the point I'm making is that if one looks at, the court was confronted with entry 25, which says gas and gas works, and the court was then confronted with entry 24, industries. Court said, if I say that gas and gas works is in 24, then of course it will fall into 52, and therefore I will, entry 25 will be left meaningless. Rather, the way court was at a situation where it says, and I'll read this just 4 lines, it's from what I've highlighted and underlined, just 3 lines above that. If industry in entry 24 is interpreted to include gas and gas works, entry 25 may become redundant And in the context of the succeeding entries, namely entry 26 dealing with trade and commerce and entry 27 dealing with production, supply and distributions of goods, it will be deprived of all its contents and reduced to useless lumber. Because my humble submission is that by removing industrial alcohol from entry 2, one would not make entry 8 useless lumber. Entry 8 would still apply fully as far as potable alcohol is concerned. Here was a case where the court was trying to see what would be left with gas and gas products if I put it the entire thing in the industry. So, Milods, if that analysis is also applied, then Milods, Calcutta Gas comes to my rescue. Leaving Milods to my last point, which I've made Milods at para 9 of my note, is that Synthetics 2 cites India Mica's case and says that within the parameters of India Mica case, if a regulatory fee is imposed by the state, and those parameters and the boundaries are set out in India Mica's case, which is time tested and recently applied in Vama Organics 2, which was read out by Honorable Solicitor General. So, Milods, as far as regulatory fee imposition is concerned, Synthetics 2 also leaves that door open for the state. So, according to me, it's a storm in a teacup, Milods, to say that we can't do anything. If you fall within the parameters of India Mica case, you can still impose a regulatory fee. Those are my points. I'm very good.
Yes, yes, Mr.
Very, very short compass. My submission would be only on the phrase is alcoholic liquor for human consumption. Although lordships are looking at entry 8, the intoxicating liquor, my submissions are just twofold. The phrase alcoholic liquor for human consumption has since been long, since the constitution has been understood as what the synthetics has said, which is to be consumed as it is. The debate has always been with regard to intoxicating liquor and the fact that whether something other than alcoholic liquor for human consumption will also be added in intoxicating liquor. So far as their submissions to say that alcoholic liquor for human consumption has to be expanded to mean something capable of also has never been any judgment of a lordship except the Bihar distillery, which makes a aberration in that to say that now you can even go and impose excise duty with regard to rectified spirit, etc. Which is not a alcoholic liquor for human consumption. So my submission to your lordships is that with regard to this phrase alcoholic liquor for human consumption, since Balsara and till Synthetics 2 and the later judgments, all have consistently as held that this phrase would mean only with something which can be consumed as it is. Whether intoxicating liquor, as what has been all argued, will also include something else, but the lordships will say, I would not wish to make those submissions on that. My only submission, I have put that how it has been followed till Utkal Distilleries, this 2022 judgment of a lordships, all have taken this consistent view except the judgment in Bihar Distillery. Now, Bihar Distillery, lordships may just note the fact that it applies a very simple test, which according to me is not correct, is the fact that it's a case of a mere dilution. In fact, it also recognizes the fact that it makes a potable alcohol or alcohol for human consumption only when you dilute it. So therefore, they imply there is an existence of a process, and the initial, that is a rectified spirit, is not something which is alcoholic for human consumption. So my submission to your lordships is, one, the test that it is a case of mere dilution is not correct, as your lordships in Winbros, in the case of an income tax, has clearly analyzed the process and has said that it is not only a mere dilution, it has to be a case where it has to be put on a specific environment, on a temperature, by addition of many other things to make it fit for human consumption. So my submission to your lordship,
Given us the note by any chance?
yes, your lordship, is 2J, volume 2J. Yes, your lordship. And one last submission to your lordship's consideration. There was a submission made that, look, today after a GST, what the states have been left with is an entry 54 is the alcohol liquor for human consumption, and then your lordship has to read it expansively. My submission to that is that, in fact, if that has been the interpretation given, there would be a substantial loss, because today, post GST, all other alcoholic liquor, including the rectified spirit and the extra neutral alcohol, all is liable for GST. So that GST also goes to state. It's not only that the center is keeping, the lordships know, it's a federal fiscal legislation. So it goes both to states and the center. Now, apart from that, for alcohol liquor for human consumption, they have an exclusive power to impose sales tax. So my submission is that what they are losing would be, in fact, a GST in case if the expansive meaning is to be given, not there has been a loss to a revenue, because that's what Shadan.
Thank you, Mr. Blanch.
If you have read.
Yes.
Small submission, my lord, for 5 minutes of time. Blood 901.16, SLP civil number 3160 of 2015. Blood, this SLP, blood, subject to outcome of your lordship decision, this is to be decided. Blood, on the ground, blood, certain duty was imposed.
What? We'll not go into the facts. You can tell us what your submission on law.
Blood, my submission is, they have imposed certain interest, blood, for the duty because of
That's
the
on
issue,
fact.
blood.
That will have to go before the regular.
Blood, the Honorable High Court,
You have to say on the questions which we have been hearing on arguments on now for the last several days.
yes, my lord, in case if your lordship is upholding the judgment, my lord, I got benefited this respondent. Suppose overruling it, my lord, the interest should not 100%,
That you can argue.
180% it is coming, my lord. Actually, more than a crore.
Yes, all right. Thank you.
Much of.
Now it has become a center versus state issue, which is rightly so. But it started out as me or the private party versus the state issue, and the legislation in question was the UP Excise Act, in light of which, and why we say it, because in light of the 3 issues which are before the court. The first issue is regarding entry 84 list 1 and the counterpart entry, which is entry 51 list 2. The issue regarding that is alcohol fit for human consumption. The second issue is regarding entry 8 list 2, which is intoxicating liquor. And the third issue is regarding entry 33 of list 3, which is to be, as per the other side, read along with entry 24 of list 2, which is on the industries aspect. And the counterpart entry in entry 52 list 1.
What do you have to add?
The only thing add is, your lordship, in the UP Excise Act, we have to see the legislative conscious from the act itself. If your lordship will see the act, because no one has shown the act itself defines what a liquor is. The UP state says liquor is intoxicating liquor, and in what it includes, they add all the beverages. So the argument sought to be made now is contrary to the legislative conscience itself. If your lordship takes the statute for 1 minute.
Where do we get it? We just make a note and then.
Your lordship, it's in volume 4, page number 682. There are 4 definitions which are important in this statute. The first is excise duty, which is at page 692. Because it says excise duty as per entry 51 list 2.
Excise duty is 692.
Then definition of liquor, which is also at page 692 bottom, your lordship. I'll just read it out. It says liquor means intoxicating liquor and includes spirits of wine, spirit, curry, panchai, beer, and all liquids consisting of and containing of alcohol. So there is no question of moving beyond these beverages or taking assistance of entry 8. The other is excisable article, which is definition at page 696. Excisable article, they specifically mention, means any alcoholic liquor for human consumption.
Yes.
And then, your lordship, section 13, read with section 19 and 28 of the Act, says that any transport or removal of these excisable articles, that is to say any alcoholic liquor fit for human consumption, will be charged with a duty. So they, in the legislative aspect, have only relied on entry 51, which as per every submission is barred by entry 82.
Thank you.
Entry 84. Much more.
Yes, Mr. Dwivedi.
I was to answer, my lord, that Tikaramji issue, my lord, if your lordships recollects, whether it is, Lord, my submission is this, my lord. Lord, Tikaramji essentially does 3 things. A, it compares the 2 acts which were in question in that petition and says that there is no repugnancy in that matter, with which, my lord, we are not concerned.
Yes.
But second, which in my submission is an obiter because that was not required to be decided, is the term industry in entry 52 list 1 is restricted only to manufacture, neither pre nor post manufacture. And third, Tikaramji does not even go into occupied field and says that once there is no notified order, the scope is open for the state to step in and legislate.
Does not go into occupied.
Does not go into it and says that, but that is clearly an obiter. It was not required to be decided. There is no discussion why one view over another view. It is an obiter. But so far as second issue is concerned,
Yes.
regarding the restricted meaning given to the term industry, but there are some legislations in place as on date referable to entry 52 list 1. So they might be impacted. In future, the parliament may require, my lord, in peculiar circumstances to control, my lord, right from raw material till the end product's usage. So, my lord, I am not, my lord, respectfully, my lord, concerned with whether Tikaramji is overruled, affirmed, or explained. My lord, that's entirely your lordship's prerogative. But, my lord, kindly bear these factors in mind. So far as second is concerned, whichever way, your lordships may, my lord, accept our submission that there was no legal or other necessity to restrict the meaning of the term industry. It is wide meaning. And if it is not so, then even entry 24 list 2 also will be impacted. Because then state also will have only manufacturing part. So I am not, my lord, against state. I am saying state also would be adversely affected. So these are my submissions.
Yes, Mr. Dwivedi.
Wait, please. We have compiled the rejoinder submissions also for lordship's convenience. The short 10 pages only, 15 pages.
Where will you find it, Mr. Dwivedi? The
Volume 1M
yes.
on the screen.
PG code. Infants code.
Digital PC.
Then you can scroll it actually. Yes.
Law, as I have been taught, and as I have learned over the years, and your lordships have hammered it in, and that is, Lord, we are a federal structure. But the power of the state under list 2 cannot be controlled or regulated by parliament. That's the concept of cooperative federalism. Federalism, your lordships have churned out, Lord, time and again. And if I would refer to your lordship's judgment.
Would you like to read that out? That para 1, para A. Let's see how you have formulated it.
No, I was responding to what was argued today.
Right at the end.
So the question is not, what we are being told is that in 1951, IDR contained industry and industrial alcohol and other things. In 56, it was modified to include alcohol under the heading fermentation. And then 16, again, it has been changed. Now I ask myself, is the jurisdiction of the state going to conform to the law laid down by the parliament? Or can parliament, by constantly modifying and amending its own act law, dictate what is contained in the state list? Lordships have very clearly said state list reserved for the states, and states have plenary power, which power cannot be controlled by parliament or by parliamentary legislation. That's absolutely clear. But yet my friends say that entry 8 has to be guided by legislation of parliament, 1951 Act. Now I ask myself, Lord, what is being argued in fact is that forget what the makers of Government of India Act 1935 had in mind when they incorporated NT 31, which is the same, verbatim the same as entry 8. What they had in mind when they incorporated entry 40, which is excise duty, same as entry 51, list 2. My friends further say, forget what the framers of the Constitution saw in the Government of India Act and these entries and incorporated that verbatim in the same manner as in the Government of India Act. My friends further forget the fact that the legislative history, if these Government of India Act and the Constitution entries are seen in the light of the legislative history, the legislative history contained both the things in the same manner as incorporated in the term intoxicating liquor in entry 31 of the Government of India Act. So what we really have to see is, what did the makers of the Government of India Act have in mind when they incorporated entry 31, this 2, that is intoxicating liquor, and in all its facets, and not anything else. The parliamentary law may say whatever it wants to, parliament may include whatever it wants to, but we cannot on the ground of parliamentary supremacy justify this kind of encroachment on the state list. So therefore, what is absolutely essential is that before we go into the issue whether intoxicating liquor means what I am claiming or what
Justice Chagla, my learned brother, Justice SHRI just pointed out, in the opening paragraph makes a distinction between the consumption of drink and foreign liquor and its application. And he then refers to also the fact that, it can be used, or eau de cologne. And he's also accustomed to the use of eau de cologne and lavender water. So he made that distinction in the very first paragraph.
what part is, and I went through that judgment more than once, no? Does it at all, I ask myself, refer to the legislative history, the Government of India Act? Because that was an act, remember, that was an act made under Government of India Act.
We may just benefit by reading the first sentence of Chagla Judge.
Yes.
Yes.
Let us read that first sentence. Sir, volume 5F, 429 Omer.
One is to
429.
drink, the other is to use. One is to drink.
434.
Bottle of
Bottles
medicated
beer,
wine.
one bottle of medicated wine, one bottle of eau de cologne, one bottle of lavender water, and some bottles of medicinal preparations.
We have an entire picture of Mr. Balsara captured by Justice Chagla in that one sentence.
Now, let's finally notice that this is in the context of the Bombay Prohibition Act, not the Bombay Excise Act. I have placed for your lordship not the Bombay Excise Act, but the definition of liquor includes everything. But besides the point, Lord, since your lordships were
Next sentence also,
very well.
what he drinks and what he uses.
That's important.
Yes.
But that was the case confined to what was caught with him under the prohibition law. And therefore, what he was trying to explain was in terms of what was caught with him. Those were drinks, there's no difficulty.
point is, does it necessarily mean that whatever he had will confine the jurisdiction of the state under entry 8? But I am on an which has been repeatedly rejected.
What else, Mr. Vedina? What else remains?
Yes. Now, but the question is, Lord, this is this is not only approved in Srilam Industrial Syndicate, but this is approved in Bansal, the Constitution Bench. This is again approved in ITC, this judgment, full bench. Lord, in ITC, which is 2002, I have narrated in page 12, and I have shown that. Again, the paragraph. Then kindly come to page 10 of my this thing, submission plus. Page 9, I have narrated those cases which have upheld.
Yes.
Then note page 10. The important aspect is not which, one of the things which my friends are raising, not this document, this argument of composite kind of a law made, which is code unto itself. Therefore, even if you don't legislate anything under the law,
Forbearance has.
it is vacant because there is regulation by abstinence, that's what it is. Now, two things which I wanted to point out. Kindly have section 18G.
We'll come back after lunch.
Apologies to Justice Why in the first place, Lord. I have given a submission 1-0, but I gave it this morning because all the submissions came on Tuesday afternoon. I was in Calcutta yesterday, but I hand wrote everything, got it typed. So I won't refer to it, Lord, since it was after 10 o'clock, but I will just.
Now. It can be incorporated at lunch now. You can just give it to the
I
court.
already given in the morning, but since Lordship said not.
Put it on the drive now.
But in fact, Lordship may make it as a part that all submission must come 24 hours in advance. So then all of us will. But this, what happened was all the submissions.
I give my apologies, Lord, for the inconvenience to your Lordship.
No, not to you, but I think Samar Vijay, right?
Yeah.
Samar Vijay, actually, I should not have spoken in that fashion. So, firstly, my, regret that these kind of words came out. But let me just put this thing. You see, when it is all paper court, whenever arguments are, we are making notes with our pen, ink, pencil, whatever, right? Now, this 9:45 thing has deprived me of this. That is the thing, right? So don't take it this thing, but it's just a matter of convenience only. That's what we say.
In 1-0, I was just attempted to answer this 6 questions referred by Lalta Prasad. Ironically, entry 8 was never referred to, but we have argued most on entry 8.
That's right. Mr. Dwivedi, another 15 minutes so that then we can hear Mr. Datar for about.
I'll take, I'm not going to rapid fire, just 25-30 minutes. Just 3 points I'm going to go.
But what I intend, subject to your Lordship's approval, you have noted their submissions. I can't argue. There can't be a surrender. Their new fresh argument on one side and our response on the right side will file by tomorrow or day after.
Then we'll keep it at that now. So
there are some new
they will
arguments.
also respond to that. They will also then respond. It will be like impossible.
I leave it to you.
So, Mr. Dwivedi till 2:15, then 2:15 to 2:45, Mr.
I take that.
We'll wrap up by 3.
Would my Lord be sitting in alternate bench?
It's gonna never end. Right. We'll see after Mr. Dwivedi ends. First, let Mr. Datta start at 2:15. 2:43 then we'll see how much time. Yeah.
1-0.